Across federal and state courts, a quiet but profound shift is unfolding in the interpretation of the Fourth Amendment. Judicial decisions increasingly favor public safety concerns over the traditional protections of property and personal privacy. By following this trend, you can grasp how the understanding of constitutional rights is evolving. For gun owners, the implications are immediate. Long-standing safeguards against searches without a warrant and preemptive confiscations are being steadily dismantled through precedents that few Americans have encountered. From doctrines designed to protect school safety, like Halish, to the emergency aid rationale in Case Versana, and to red flag approvals in Willie v. Brown, courts are laying down a new constitutional principle. They are affirming that the right to life and public safety can outweigh the right to privacy. In Willie v. Brown, the court explicitly held that reasonable grounds required by red flag statutes equates to the probable cause threshold set by the Constitution. As a result, states now possess constitutional backing for preemptive gun confiscations. This reinterpretation is gaining momentum heading into 2026. Understanding how courts justify prioritizing public safety over privacy is essential, particularly when wellness checks or neighbor reports are invoked as reasons for searches without warrants or firearm seizures. A recurring pattern emerges across multiple domains: school safety, the Halish Doctrine, emergency aid cases like Montana, red flag laws such as Willie v. Brown, and even immigration enforcement. When public safety collides with Fourth Amendment privacy rights, courts consistently side with safety. This judicial trend reflects what they describe as a sociological concern about armed violence. Judges acknowledge that the pervasive fear of mass shootings has influenced them to reinterpret privacy protections, enabling preventive government interventions. Examining the case patterns reveals a systematic weakening of Fourth Amendment protections. In school-related cases under the Halish Doctrine, courts ruled that administrators may conduct searches of backpacks, phones, and even vehicles without a warrant, provided there is reasonable suspicion, a standard lower than probable cause, when preventing school violence. In Case Figge, Montana, the Supreme Court established that officers may enter homes without warrants if they have an objectively reasonable basis to believe someone inside is at serious risk of injury. For gun owners, this means that during a wellness check, police can observe firearms, prompting a red flag petition. Willie v. Brown further solidified this approach. A federal judge upheld Maryland's red flag law permitting gun confiscation based on reasonable grounds alone. The civil standard, 50% certainty, is sufficient to justify intervention aimed at preventing gun violence without pressing criminal charges. The court clarified that reasonable grounds fulfills Fourth Amendment requirements, even though it falls short of the traditional probable cause standard. In immigration enforcement contexts, courts have likewise sanctioned warrantless searches by authorities when public safety is at stake, highlighting a unifying trend. Fourth Amendment standards are being lowered from probable cause to reasonable grounds, reasonable suspicion, or an objectively reasonable basis whenever safety concerns are invoked. Traditionally, the Fourth Amendment safeguarded individuals against unwarranted searches and seizures of persons, homes, papers, and possessions. The government needed a warrant supported by probable cause, a 50% likelihood, to conduct searches or seize property. This framework prioritized individual privacy over state intrusion. The new judicial philosophy articulates a different hierarchy. When life and safety interests come into conflict with property privacy, life and safety take precedence. Courts now openly recognize this approach, emphasizing that preserving human life and public security can justify intrusions that were previously constitutionally impermissible. Across all the cases, from schools to emergency aid, red flag laws, and immigration enforcement, the message is consistent. Public safety has become the paramount concern, reshaping the way the Fourth Amendment is applied. Individuals, particularly gun owners, must be aware that reasonable grounds, or an objectively reasonable belief, can now legally trigger preemptive actions by authorities. The constitutional shield against warrantless searches and seizures is no longer absolute. It is flexibly interpreted to accommodate the court's prioritization of life and safety over privacy. This shift represents a deliberate judicial philosophy, responding to societal fears of mass violence. Courts have systematically established that in scenarios where the threat to life is perceived, government intervention is not just permissible but constitutionally sanctioned. Whether it is a student's backpack, a home welfare check, a firearm in private possession, or administrative immigration enforcement, the pattern is unmistakable. Public safety trumps Fourth Amendment privacy rights, creating a new legal landscape where preventive measures take precedence over traditional property protections. Maryland's compelling interest in preventing gun-related tragedies and suicides provides legal justification for temporarily seizing firearms without filing criminal charges. In Case v. Montana, the courts emphasized that when immediate medical attention is needed, the Constitution does not demand that officers remain outside. Similarly, schools are permitted to search students' belongings because the prevention of shootings takes precedence over the privacy of backpacks. This represents a deliberate constitutional reinterpretation. Courts are not claiming that the Fourth Amendment is irrelevant. Rather, they assert that the definition of an unreasonable search must be adaptable when public safety is at stake. What counts as unreasonable now depends heavily on context. In traditional criminal investigations, any search without a warrant is considered unreasonable unless supported by probable cause. Yet, in contexts such as school safety, red flag interventions, or emergency aid, warrantless actions can be reasonable under lower standards because the preservation of life outweighs personal privacy. Courts explicitly reference the public's fear of armed violence as part of their reasoning. Halish noted that the epidemic of school shootings created a sociological climate necessitating expanded search powers, while Willey highlighted the compelling interest in preventing gun tragedies. Judges observe that American society is so apprehensive about gun violence that constitutional protections must yield to preemptive measures. The practical consequences are significant. If courts broadly endorse the supremacy of life and safety, virtually any government action involving firearms could be justified. Red flag confiscations, warrantless entries during wellness checks, and emergency interventions all fall under this logic. Life safety now permits authorities to act on reasonable suspicion alone. Under Willey v. Brown, reasonable grounds is equated with probable cause, effectively constitutionalizing preemptive confiscation. Maryland law now allows a judge to authorize gun seizure if there is reasonable belief that an individual poses a danger. This civil standard, a preponderance of evidence, 50% certainty, requires no criminal charge or conviction. Temporary confiscation can occur solely based on a civil finding of potential future harm. Challenges to this approach were raised in Willey and by SAF, arguing that seizing property without traditional probable cause violates the Fourth Amendment and that the civil standard is too low to deprive constitutional rights. Judge Herson, however, concluded that reasonable grounds satisfies Fourth Amendment protections. The court reasoned that in this preventive civil context, the question of whether sufficient facts support a reasonable belief functions similarly to probable cause. While the Fourth Amendment requires probable cause for criminal searches, red flag proceedings are civil, designed for prevention rather than punishment. Through this reasoning, the court effectively transformed the civil reasonable grounds standard into the constitutional equivalent of probable cause, redefining Fourth Amendment requirements within a preventive framework. This precedent opens the door for states to enact broad preemptive confiscation laws using civil standards while remaining compliant with constitutional protections. Following Willey, states now have a constitutional green light to seize firearms before any crime is committed or charges are filed, based on civil findings indicating potential future danger. As long as procedures include a hearing and rely on reasonable grounds or a similar civil standard, the Fourth Amendment is considered satisfied. For gun owners, this redefinition fundamentally alters Fourth Amendment protections at home. If police cite an emergency, conduct a wellness check, or respond to a noise complaint, they can enter without a warrant under Case v. Montana's reasonable basis standard. Once lawfully inside, the plain view doctrine permits observation of firearms. Such observations can then serve as the basis for a red flag petition, leading to preemptive seizure of property under the Willey framework. Ex parte orders allow confiscation before any hearing, and the burden falls on the individual to prove at a subsequent hearing that they are not a danger to regain possession. Children's privacy is similarly affected. Under the Halish school safety doctrine, schools may search students on reasonable suspicion when safety concerns exist. Discovery of firearms or ammunition can trigger school discipline, criminal charges, or red flag actions against parents. The combination of civil standards, preemptive authority, and flexible interpretations of privacy has created a legal environment where preventive safety measures consistently take precedence over traditional Fourth Amendment protections. Across multiple legal arenas, traditional Fourth Amendment protections are steadily being weakened. Courts are now permitting government intrusions using standards lower than probable cause whenever public safety is invoked as justification. This shift reflects what judges describe as a sociological phobia of armed violence, which legitimizes a flexible interpretation of the Constitution, prioritizing prevention over individual privacy. Following Willey v. Brown, red flag laws have multiplied, embedding the constitutionalized framework for preemptive confiscation. By 2026, 21 states plus Washington, D.C. have enacted such laws, each applying civil standards that courts have recognized as compliant with the Fourth Amendment. The same judicial reasoning is appearing in immigration enforcement, where warrantless searches are upheld under public safety and administrative necessity, demonstrating that the supremacy of life and safety is not confined to firearms, but extends wherever courts perceive a safety emergency. For individuals navigating this legal landscape, documentation is paramount. Whenever police enter under an emergency exception, a school searches a student's belongings, or a red flag petition is filed, every detail must be recorded: dates, times, the people involved, statements made, justifications provided, and observations. This record becomes critical in challenging government actions later. Consent should never be given lightly. Inviting officers inside during wellness checks or agreeing to searches beyond legal requirements can nullify Fourth Amendment protections entirely. Volunteering information is equally dangerous. Once consent is granted, privacy rights erode rapidly. Understanding your state's red flag law is essential. If such a law exists, know who may petition, what standard must be met, the timeline for hearings, and what evidence you are allowed to present. In all 21 states, plus D.C., securing firearms from plain view is crucial. Should police enter lawfully under an emergency exception, anything observable becomes fair game. Firearms, ammunition, and tactical gear must be stored in safes or locked rooms to prevent them from being seized. Avoid circumstances that could trigger wellness checks. Loud disputes, heated arguments with neighbors, and social media posts expressing distress can all provoke a law enforcement response. If police do enter and observe firearms, or if a red flag petition is filed, or if a school finds weapons, obtaining an experienced firearms attorney immediately is critical. Cases move fast. Ex parte orders can be issued within days, with full hearings following in 7 to 14 days. Legal counsel can challenge whether the police had an objectively reasonable basis, whether the petitioner established reasonable grounds, or whether school officials had valid reasonable suspicion. The broader legal pattern is unmistakable. Courts are systematically interpreting the Fourth Amendment's unreasonable search clause to favor public safety over property privacy. Hollish school safety cases allow searches on reasonable suspicion. Case versus Montana emergency aid cases permit home entries based on an objectively reasonable basis. Willie v. Brown authorizes gun confiscation on reasonable grounds. Immigration enforcement validates administrative searches. Across all these contexts, standards fall below traditional probable cause, consistently justified by the pursuit of public safety. The underlying judicial philosophy is clear: life and safety take precedence over privacy. When interests in preserving life collide with privacy rights, life safety wins. The Fourth Amendment must now be interpreted flexibly in contexts where public safety is at stake. Courts invoke societal fear of gun violence to justify these constitutional shifts. Under Willie, the court held that reasonable grounds derived from civil proceedings functionally equate to probable cause within the red flag context, effectively constitutionalizing preemptive gun confiscation authority. Governments can now seize firearms before any crime occurs, before charges are filed, based solely on a civil prediction of future danger. This has eroded protections. Homes are less secure, emergency exceptions make property vulnerable to preemptive seizure, red flag laws impose constraints, and children's privacy is diminished through school searches. What steps can you take? Document everything meticulously. Never consent to searches. Learn your state's red flag law in detail. Keep firearms out of plain view and avoid circumstances likely to provoke wellness checks. Seek legal counsel. Immediately, if you are targeted, challenge government actions whenever possible. Courts are accelerating the reinterpretation of the Fourth Amendment, steadily eroding constitutional protections for gun owners, but awareness and preparedness can make a tangible difference.